Nestled in the rolling hills of western Pennsylvania, Washington County's Independence Township is at a crossroads. Once known for its quaint churches, farms, and lonely, winding roads, it is now at the epicenter of the Marcellus gas development boom. But economic progress has come at a steep price for the environment, communities, and industry workers like Richard and Frank Lancaster. When companies like Chesapeake Energy and their contractors trade safety for corporate profits, tragedies follow.
It sounded like a bomb went off. And it was like somebody dropped a 1,000-pounder.
It was just a really loud bang, and I actually felt my house shake.
The whole house rattled. The windows, everything.
I was really alarmed. I didn't have any idea of what it was. I'd never heard such a loud bang.
This was a tragic sight. The entire horizon here behind me, a burning glow of orange. Hundreds of firefighters trying to keep up with the flames. Sky 4 flying at a safe distance. Meanwhile, the ground literally shaking the small Avila community.
And they were doing CPR on one man, and he said it just looked terrible. He said everything was on fire.
The gas company says 3 male workers were severely injured in the blast. Witnesses say countless others were burned.
And Team 4 digging deeper into this mess tonight. They uncovered Chesapeake Gas owns the well. Now, if their name sounds familiar, it should. Chesapeake Gas was also responsible for the gas well explosion and fire last June in Moundsville, West Virginia, a fire which burned for 3 days.
Despite worker deaths, injuries, multiple citations, and penalties for past violations at its other sites, Chesapeake has done little to improve its safety practices.
I talked earlier today with the emergency management chief for Independence Township, which is where this fire occurred. He told me flat out Chesapeake Energy has not done enough to keep folks safe. As the fire raged Wednesday night near Avila, Emergency Management Director David Howard kept waiting for outside experts to be called in. He says that's what driller Chesapeake Energy had promised, but they never showed. Chesapeake didn't live up to what they had told us at all, he told me. It's a mess.
No incident or accident is acceptable, and we will aggressively learn the facts surrounding this incident, and we're committed to continuous improvement in all of our operations.
The facts detailed by the state fire marshal and OSHA investigators were unchallenged and agreed to by Chesapeake in its May 2011 consent order and agreement. Chesapeake acknowledged that it was the gas well owner-operator and controlled access and activities at the well site. Chesapeake knew there was a dangerous accumulation of combustible vapors on site. Chesapeake knew there were multiple ignition sources on site. Yet Chesapeake chose to ignore worker safety and intentionally expose these men to extremely dangerous conditions regardless. The glycol heaters and 500-barrel condensate holding tanks were ordered by Chesapeake and supplied by its corporate affiliate, Great Plains Oil Services. The holding tanks had an open-top design, allowing dangerously combustible vapors to flow over the tank sides as the liquid levels rose. Chesapeake's use of the open-top tanks was a clear deviation from industry practices and safety standards, tanks that Chesapeake had never used before or since. Chesapeake Completion Supervisor Zach Arnold.
Now, does Chesapeake make a practice of using, or back in February of 2011, did Chesapeake make a practice of using open-topped flowback tanks?
No.
Other than these two open-top flowback tanks at the Joseph Powers well site, had you ever seen during the time, any of the time you were working for Chesapeake, had you ever seen a tank like this used during a flowback process?
No.
since February 23rd, 2011, have you ever seen an open top flowback tank in use on one of Chesapeake's well sites?
No.
Would you agree with me that this is kind of an extraordinary, out of the ordinary situation?
Since it had never happened before, I would consider it abnormal.
In his signed statements and interviews with OSHA investigators, Chesapeake completion foreman Jim Russell confirmed that he knew combustible vapors were flowing out of the condensate tanks on February 23rd, the date of the incident, and in the days prior. And Russell also knew how dangerous those vapors could be if they came into contact with an ignition source, of which there were many on the Powers site.
There was some indication in the OSHA report that the heaters were not intrinsically safe. Do you know what that means?
My understanding is that that means that the wiring is not such that it can be placed in a gas-filled environment without risk of ignition, but that's only my understanding. I don't know that to be true.
Co-defendant H&H Oilfield Services owner Dwayne Hickman recognized the problem and told Russell about his concerns over the large amount of combustible vapors on site. Yet, despite both Chesapeake and H&H's knowledge of imminent danger, they did nothing.
I want anybody working for me that sees something that they don't feel safe about to call me, regardless of the situation.
In this instance, that is not what occurred, correct?
Correct.
And since Mr. Russell didn't notify you about it, you didn't have an opportunity to take any corrective action, true?
True.
I'm asking you, as the completion supervisor for Chesapeake, whether you believe a reasonable and prudent completion foreman would warn his supervisor of the existence of an extraordinary amount of condensate vapor at a well site.
I believe it would be reasonable and prudent to make me aware of that situation.
Would a reasonable, prudent completion foreman warn all other persons working at the well site of the existence of an extraordinary amount of condensate vapor?
That would be reasonable and prudent to do as well.
Okay. Would it be reasonable and prudent to shut in a well if you thought there was an extraordinary amount of condensate vapor at a well site during flowback?
Objection. That would be a normal action to take, yes.
Okay. Would it be a reasonable and prudent step to clear the site and personnel from the site until the conditions dissipated?
Objection. Again, it would be reasonable and prudent depending on the level of risk that was involved.
The OSHA inspector puts it best. In a nutshell, Jim Russell knew by seeing and smelling the hydrocarbon vapors rolling out of the gas buster tanks since Monday, February 21st, through the time of the fire, and the only thing he did to prevent the possibility of a fire was to curtail non-essential activities. This left numerous sources of ignition operating. There were 3 open flame flares with fire coming out of the flares at least 20 feet high, and 2 glycol heaters that had flames. The closest flame-producing piece of equipment was the small glycol heater approximately 43 feet away from where 2 employees told the CSHO they saw the fire start.
I understand this was a handwritten statement that was written out by someone in response to your verbal statement. Is that fair?
That's fair.
Okay. It says, I did not see a flash or a fire under any of the water trucks. There were 2 water trucks up there, sir?
Yes, sir.
Okay, and you're telling OSHA you didn't see any flash at the water trucks, correct?
That's right.
Okay. Did they ask you whether you were smoking or not?
Yes.
Okay, and you told them you don't smoke?
I don't smoke.
Did you see anybody smoking up there at the site right at the time this happened?
No.
Okay. And then I'm going to continue on the statement, all right? I am as sure as I am sitting here that I saw a bluish-reddish color flash between the 3 well heads and the separators, and then it quickly moved to where, and there's a redaction, men's names were inside the containment wall. There was a short flash that went from between the well heads and the separators, and the flash very quickly traveled back to the diked area, and then the 3 men above were engulfed in a fire.
Yes, sir.
Period. Okay. Is that accurate?
Yes.
Okay. That's you telling OSHA what you actually visually saw out there, correct?
Yes.
Okay. If someone tried to tell you today that the fire started over at the water tank trucks, you would say with absolute certainty that's not the case, correct?
That's correct.
Okay.
Russell confirmed Field's account of the fire's origin in his OSHA statement. As evidenced by the May 2011 consent agreement, Chesapeake's violation of state and federal regulations directly led to the explosion on the evening of February 23rd, which left both Frank and Richard Lancaster with devastating lifelong injuries.
You know, February 23rd, 2011, and Chesapeake allowed a bad state of affairs to exist on the Joseph Powers well site. True?
An accident occurred, and therefore there was an unsafe condition that was there. If you want to call that a bad state of affairs, okay.
Well, would you agree that that's a bad state of affairs?
I wouldn't. I would agree that that's not the way we want to operate.
Because people can get hurt, right?
Correct.
People can get burned, right?
Yes.
And people's lives can be impacted, right?
Yes.
Their families can be impacted, right?
Yes.
As a direct result of its reckless actions, Chesapeake has been ordered to pay a civil penalty totaling $188,000 and to implement measures to protect the environment, the public, and its own workers from such a tragedy. Unfortunately, these measures came too late to help Frank and Richard Lancaster. Frank Lancaster suffered second and third degree burns to his face, head, neck, and wrists. For several months following the explosion, he continued wound care and debridements and underwent skin graft surgery on both of his wrists. Frank is permanently disfigured and continues to have pain, tingling, and itching at the burn sites, and suffers from dry eyes, persistent nightmares, insomnia, depression, and has been diagnosed with PTSD. Frank Lancaster's injuries and the aftermath have prevented him from returning to work in the oil and gas field and have affected his activities of daily life, interactions with his wife and 4 children, and his ability to enjoy hunting, fishing, and other recreation and hobbies. Richard Lancaster suffered second and third degree burns to his face, chest, neck, and hands. He was intubated in the field and admitted in critical condition at the UPMC Mercy Burn Unit, where he was placed on a mechanical ventilator for respiratory failure. He underwent wound excision, debridements, and skin graft surgery on both hands. Richard is permanently disfigured and continues to have severe pain in both hands. He suffers from persistent nightmares, insomnia, depression, and has been diagnosed with PTSD and type 2 regional pain syndrome, for which he continues to receive treatment. Richard Lancaster's injuries and the aftermath have prevented him from returning to work and have affected his activities of daily life, interactions with his wife and children, and his ability to enjoy the hobbies and recreational activities he had prior to the explosion. Frank Lancaster and Richard Lancaster's damages are significant. Frank's total economic damages in this case are in the $620,000 to $770,000 range. Richard's total economic damages are between $1.08 and $1.4 million. Both of these men's injuries were catastrophic, and ongoing recovery is painful and frustrating. The Lancasters face years of additional therapy and medical care, and while the economic losses for both are considerable, the largest measure of damages is the pain and suffering, mental anguish, physical impairment, and permanent disfigurement that each will live with for the rest of their lives. West Virginia juries routinely award damages of 3 to 5 times specials in cases like this. The simple fact is that West Virginia juries compensate injured victims, especially when businesses have acted in reckless disregard of public safety, as in this case. But for Chesapeake, H&H, and SCS's negligent and reckless conduct, Frank and Richard Lancaster would not be in this unfortunate situation today. And while no amount of money can make up for the harm done to these two men and their families, settlement of their claims today will allow them to move on from a painful chapter in their lives. We welcome the opportunity to work with you going forward to resolve this matter for all parties involved.